morning. It is 10:05 on goes to show how much stress this is under. Thursday, November the 5th, 2020. So we sent the letter out. That's a complaint, specific in writing, explaining we've already gone through the other processes, explaining our difficulty with having this brought forward. But this isn't even really a human rights issue, nor a disability issue, nor should it have been, ever. It shouldn't even been a landlord-tenant issue, had they done their job properly. Because again, what we're talking about here is that taxpayers pay for taxes for services, and one of those services is to have housing inspections when there is suspicion of impropriety and unlawfulness. And well, the law is clear, and here we have this situation. And again, hardship is about the cost outweighing the benefit in degree of difficulty. So you be the judge. Had they done their job, which is their duty under law and minimum due diligence, and that goes for any of them, whether it's the ministry, whether it's the government, whether it's legal aid, whether it's Law Society of Upper Canada and Osgoode Hall and all the universities and whoever's responsible for educating these people and regulating them. What are regulations for if you're not going to enforce them? And what enforcement? The only enforcement going on here is that don't complain. Don't ask for what you're supposed to get. Don't expect it. So cost outweighs benefit. How much does it cost for 4 inspections? We've certainly pushed the line where it says that there's a problem here and it needs to be looked at, especially when it comes to the behavior and conduct of those persons that are supposedly conducting their investigation. See, the problem is this. The license bylaw says it must be posted in a prominent place on the property. When I discovered the law, of course, you read it and you say, well, that's not here. And let's discuss just the reason why that would be. First of all, to let the tenant be aware that it is properly licensed and who is responsible for that application. Should they have any concerns or whatever. And it's also part of Landlord-Tenant Residential Tenancy Act, where it says that the tenant shall know the name and address of the owner and or property management that and contact information. So it settles a couple of those requirements. But here's the thing. They caught him without cooperating. There was no, the license was here for the previous landlord when we moved in. We didn't know it had to be posted, but regardless, we don't have to know. The law says, as a matter of fact, if you look at the one for 2020, it says specifically on it, this license must be posted. And yet, Shane Turner and them didn't make sure it was posted. You can go and see the video of 98B where, again, it wasn't posted. That is a direct infraction of the rental bylaw. But again, let's get back to 100A. So had it been, if you look at the license, I believe it was June 19th or 20th or whatever that they got granted the license. When the work order was June 13th and they were required to get it done by July 15th, so they should never have gotten a license granted before July 15th. But let's take that aside again. So they're granted the license, they're required to post it, and they didn't. They kept it secret and took it out at the Landlord-Tenant Board hearing as a ta-da moment, which even the person overseeing the hearing remarked was, that's not proper. Okay? It seemed to us. And we've got the whole thing on, like, again, this is where people don't understand. Every hearing that I've been in, I've got a copy of, because I recorded it as a person with a disability. So the pattern behavior's there. But anyway, back to this. So their requirement is to post it. And it's the requirement of the municipal enforcement to make sure it is posted. When we became aware of this law and I found out that it's unlawful to pay rent question, my simple question in the letter is it unlawful to pay rent? Like, are we breaking the law if we pay rent? First of all, is it licensed? We asked it, like, they did not give us any information. They gave us misrepresented information. But here's the biggest thing. By not having it posted on the wall was an interference in and also deliberate manipulation of the situation against us. And also using our disability against us. Because they use any tool at their disposal, because the whole point is they've been found out. This is proven. Okay? And they don't want to go the final step. I don't care. Okay? But the point is, had they put that license up, and this is what we were going to say and what we were trying to say at landlord-tenant, but every time we got closer to actual facts, they turned up the heat as far as provoking and not allowing us the space. Like I said, it's using your disability against you, the whole thing. And just the fact that it's a traumatic experience in the first place. And again, we shouldn't have been there. Had they done the inspections, the law would have taken care of itself, and we would be living there as people with disabilities who just found a 3-bedroom, semi-detached, in that, it was supposed to be fenced-in backyard, which was part of the agreement, and also it's part of the law, because look at the fencing back there. You're not allowed to have park fences. But hey, they don't want to answer those questions. Anyway, the point is, had they hung that license up or answered the question, it changed the whole dynamic of how it was done. And again, he had the rent check, including June's check, which he could have cashed at any time. He'd been doing it for 2 years prior. Never missed a payment. Never defaulted on a payment once. And he deliberately held on to the check because I presume, because I said, hey, he starts doing this thing about we're not paying rent. I said, go ahead and cash the check. But to do so would have been unlawful. So they covered his butt for June, didn't tell us about it, played us the whole way through it. As soon as they got us whipped up enough and they got the stage set that, oh no, the landlord's covered for June now. And we got these guys so twisted up that, again, because the whole question was, is it lawful to pay rent? And they interfered with even just a simple piece of information to exploit it on the taxpayer's dime. Mr. Finance Minister, Mr. Municipal Affairs and Housing Minister. And we need to submit, we need to find out how much would it have cost for them to have them just show up and do the 4 inspections. And to go through that process. The average process of doing, and with real enforcement. They're taking what, because my knowledge of being president of a co-op before my brain injury. I was president of a co-op for a period of time. I think it was almost 2 years or something like that. Most of which was dealing with bylaws, and especially with the city, because again, same pattern there, where under contract says one thing, they don't do their job, they cut corners and stuff, and what was going on at that co-op was unbelievable. I mean, it was criminal what they were doing at these co-ops. But again, Ministry of Housing, right? And CMHC had big contracts for retooling and upgrading and fixing what should have been done in the first place. And again, nothing but hearings and services and ka-ching, 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 ka-ching. Because you know what? Here's a perfect example. They don't do their job. By them not doing their job, look at how much money has been generated. Lawsuits. Look at the Landlord-Tenant Board. Look at the Workplace Safety and Insurance Board. Both of these places, which are overseen by police services inspectors, they are under Police Services Act in order to go in and do their investigative problems. And here it is, the same thing. They are interfering with and this is like Walkerton, where I was trained to do that. That's how they told me to do it. And then they covered with willing partners. Anyway, so what's hardship? I mean, how hard is it to do the inspections? And that's the real question, because disability and all that aside, I mean, the fact that we're disabled and now they're saying, like I said, the cyclical thing, I mean, it's just a merry-go-round at your expense and at our expense. It's difficult. Now that I'm aware, 100% of where we are, like I said, this isn't a matter of it's on a matter of record. Go to landlord-tenant. Go to their judgment section, but what you pay attention to is how many of the same landlords with the same address, with the same issues. They technically allowed another family to move in 100A Marshall Street when every last one of them knew it was not to code. Because Ministry of Municipal Affairs and Housing considered the case closed once they got what they wanted, which was set the stage. We went to landlord-tenant. I had done all the research, most of which is posted along with the actual claims in this series. That if you go to the description part, you can actually follow the links where it'll take you directly to the evidence. And this has already been given to, first of all, it's the law. So where do you go when the law doesn't want to follow the law? They got caught and they don't want to answer for it. It's like the We Charity scandal. We don't need to know. What we don't know about what they're up to won't hurt them. Anyway, today I don't want to go too long. I just need to say that, put it in context. I still don't understand why people aren't getting this. But you know, that's not the problem. My problem is protecting 4 people and trying to get the law to work. My responsibility has been thrust on me. Because again, I didn't want any of this. This is not good for my PTSD, and that's why they're making us do it. The whole point is make you feel powerless. And don't we all feel powerless? We need, they keep you in the landlord-tenant. So what we need to do possibly, and I can't believe we're saying this, they're going to make us go to human rights, and they have been so far, making us go to human rights in order to get due diligence done. And every level we get to, they just send us back to go, which creates more services. And I guess once we're homeless, there will be a whole bunch of services ready for us, right? Because that's the focus on government now. This thing about when people don't agree with you, you're not supposed to be able to punish them. In Canada, what do you stand for? No more rhetoric, no more Joe Canadian bullshit. What do you stand for? Because so far, with every level of doing this, whether we go to the board and present every piece of lawful evidence, besides the fact the law itself is very clear, all of which is binding on municipal affairs and housing. Again, these two, Ministry of Municipal Affairs and Housing and Labor, can't get it right. It's the same pattern of behavior. They're interfering with inspections. They're not doing enforcement. Like at the employer, he was without a proper health and safety policy until a year after my accident. After I started fighting back with that, and again, using the truth. It's already in the file. Shut out from that too, because again, security of person, health care, employment, housing, education, all of which are necessary for security of person, all of which are controlled by quasi-judicial tribunals where precedent doesn't matter, even to the point where it's a work order on 100A. The same conditions exist in 98B, and yet, like a guy with 2 cars, he just got pulled over with a fleet by the Ministry of Transportation. He's got 4 vehicles here, and they go, well, we're checking one, and it's got really bad brakes and everything like that, but we're working with him. More like working for him. Tipping the balance of power, because it serves a purpose for both of them. Certainly not serving the purpose of the taxpayer. Because again, it's meant to, they win no matter what. They're not following the law, so we get to go to tribunal again and again and again. We get to get community legal services again and again and again. We get to go through this merry-go-round every single time when all they had to do is follow the law. And you got to ask yourself, with all these repeat offenders, like the biggest repeat offender we're trying to stop is the ministry itself and the legal system. This legal system is based on indentured servitude to the crown. The law in Canada is that they are ministers to us from the Crown. They administer the law to the subjects of Canada. You and I are all subjects of Canada. This is not America. This is not a free society. This is a rape and pillage society of indentured servitude, and just spin. And look, I mean, here we got age-old thing again. Notwithstanding is in the Constitution, and we're seeing examples of it now. I was saying what notwithstanding means because I've been treated notwithstanding for 16 years. You have any evidence against them like this? We have evidence against them. It is clear we're notwithstanding. Our evidence doesn't have standing. We don't have standing. The only thing that has standing is this landlord, the banks, and their agenda. With regard to the license application here for 2020, again, they know it's not to code. Same issue, and they're just steamrolling over it because they know, put you in the system, and hey, they just make a whole bunch of money making you nuts and using psychological warfare against you. In any other circumstance, it's clear this is psychological warfare using your disability against you. And using the law to break the law by not following the law. So let's go into court and argue about it, or all the damages that have been done. You have a lawyer, lawyer somewhere, help Theo Papadopoulos, a registered, licensed, certified real estate agent actively in the profession right now, allowed him, gave him a document, because again, the law says it's residential standard form. The only form that lawyer should have handed him was a residential standard form. And if he had did it when it was legal to do it that way, the minute it became residential standard form, he should have transferred it to residential standard form and not allowed him to do anything else in that marketplace, because as an officer of the court, to do anything else is manipulation and fraud. And if he's drawing up the document, and he had to give advice, and he's doing things like leave harmless and blameless, so why would you do that in a lease unless you're intending to harm somebody? Especially when you're acting like this. And it's not legally binding in this situation anyway. And even for the people working for the government, only if they act in good faith, which includes lawfully, are they protected from prosecution or criminal charges. Again, it's just because willing partners. Kerry, all of us have been assaulted. You've seen the result of my unlawful arrest. I have told you what happened in the hospital. I told you what, it doesn't matter. You try to get the records, then you got to go get records, then you got to go get the right person, then you got to fill it out right, you got to go through it again. Again, what's hardship? When all they have to do is follow the law. In the hospital, medical error led to my, if they would have done properly, I would not be as harmed as I am. Same pattern of behavior. Deny, deflect, obstruct, victimize, criminalize, based on lies. How do you defend against this? Anyway, we're asking for your help. You need to get these people to perform a simple inspection on behalf of the taxpayers. This has not, the landlord-tenant is a distraction. It's a device. It's a mechanism. And if this case doesn't prove it, then we never will. And again, we all know they only run from what they know is true already, and they're trying to hide. So we ask for your help. But anyway, so the letter's clear what we sent out. Again, even for Human Rights and Legal Support Center, again, we've been doing that repeatedly with no response. And surprise, surprise, no response this time either. Apparently they let the hearing go ahead. We don't know what the outcome was because, as I said, we didn't participate. We're not participating in that. There's no sense to, because we've given them everything before. It was acknowledged. Here, actually, I'll switch to that one first. Where are we? Okay, so we got a couple responses. So that's what this is. Invite you to I'm just going to show that this is my Marshall Street Tenant Association address. With regard to SWL 41948-20 from Justice Meg SJTO Southwest LTB email on November 2nd, 2020, 8:47 in the morning. Hello, this is confirmed that this email and attachments has been received and added to the file as tenant submission to be considered at the hearing scheduled for November 4th, 2020 for file SWL 41948-20. Karina, Customer Service Officer, LTB Southwest Office, London. Now, the problem with this, again, is that they get you procedurally because, again, there's been a lot going on. We've been asking for help to do this again. Be nothing but roadblocks. You get all the psychological problems with the PTSD built up and frustration, which is, again, deliberate. That's an act of war. That is war crimes under the War Crimes Act, especially as written. And you don't have to be in a state of war. But I would submit that they have said they are at war with poverty. The war on poverty. I would say maybe that is. Anyway, it doesn't matter. It's about the behavior. But the problem with this is that procedurally, because of what's going on, we would require subpoenas. And in order to do a subpoena in Landlord-Tenant Board, you must request one. And we're going to reluctantly, but explain the situation like we did, which is basically there's so much unlawful rent paid to date, and we've got 3,600 of it holding here, which they've been neglecting to pick up. Again, trying to recreate the situation that they did next door. Exact same playbook, and here we are. So again, in order to do that, because I would have subpoenaed the property manager for Atlas Property Management to answer for the questions of what happened with that application, to get it a matter of official record, because when you testify under landlord-tenant, it is under oath. So with regard to the previous submission, which I said, the landlord and Ministry of Housing perjured themselves. Matter of fact, Ministry of Housing didn't cooperate at all, and Landlord-Tenant Board is directly under Ministry of Housing. This is the only place where they can be held accountable, according to the system the way it is now, which is exactly our complaint. Okay. And again, Community Legal Services, no, they don't do that. It's like, no, let's just get the rent paid. Let's just put that all to bed. Look at the history here. Municipal Affairs and Housing became aware of this, so guess what? You don't need it. That responsibility is squarely on Municipal Affairs and Housing, because they are supposed to come in, do it one time, it's to code, and that's the standard. Okay, so I don't want this to go too far, but we did get a response from Ministry of Municipal Affairs and Housing. Laura Lee Riddell, obviously, is the person tasked with the of sending it, on 2020, November 3rd at 5:42 in the afternoon. See, Tuesday, 5:42. So, dear Chris Bacon, please see attached for correspondence from Ministry of Municipal Affairs and Housing. Thank you. Laura Lee Riddell, Carpenter, Business Support Officer, Municipal Services Office, Western, Ministry of Municipal Affairs and Housing. Now, I sent it to the minister as well, and I said I want a written response from each person. So, they sent this back. And we'll read it. This is actually Ian Kerr, the manager, that's responsible for the actions of his underlings, being everybody from Shane Turner and everyone in his department, everyone who participated in the misrepresentation and which they're using as a matter of record right now. But they're ignoring. They ignored it completely the last time, because that's why it's an unlawful and improper decision made by the Landlord-Tenant Board with regard to what happened at 108. Especially with regard to the obstruction of justice with presenting our case in the first place. And the reason why they do that is because they know what's going on. Okay, anyway. November 3rd, 2020, Chris Bacon, Director, Marshall Street Tenant Association. Dear Chris Bacon, I am writing in response to the phone call you made to me on October 30th, 2020, and the correspondence you provided me by email that same evening, which was also addressed to several others, including the Minster of Municipal Affairs and the Minister of Finance. I am sorry to hear about the difficulties you're experiencing. So does that mean they're trying to say this is the answer for everybody? I'm sorry, the letterhead here is Minister of Municipal Affairs and Housing. And it's from the person who has the most to lose by the truth coming out. So, Minister of Municipal Affairs and Housing, this is not a written response to our inquiry from you. We need a direct response from your mouth as to the aspects of this case. As do we with Premier Doug Ford, the Attorney General, even if it's a form letter again. Your official response to the query is required. So, let's go back. The Residential Tenancies Act 2006 RTA is the legislation that governs residential tenancies in Ontario. The Landlord-Tenant Board is the adjudicative tribunal with the authority to resolve disputes between landlords and tenants. This is where it goes to the form letter, mostly. The LTB operates independently from the government. Well, you be the judge. And we do not comment on individual circumstances so as not to interfere with any current or potential future cases. However, I hope to provide you some general information about the RTA, which is Residential Tenancies Act, and tenant rights that you may find helpful. Now again, a specific complaint with specific qualified questions. You noted that you have an upcoming LTB hearing in respect of unpaid rent. At an eviction hearing, tenants may raise a breach of another obligation of the landlord under the RTA. The LTB is required, before granting an eviction, to consider the circumstances of each case to determine whether or not the eviction should be refused or delayed. Okay, so we gave them everything for 100A. And there was even a stay that was interfered with at the last minute. Community Legal Services wrote the stuff out for Denise but refused to intervene on her behalf. When she went there, I was representing myself, which also happened to represent her rights. When she went to go to Community Legal Services to get her rights represented, they went, nah, that's okay. That's not the mandate, is it? And all because, again, they all know what's going on. They're all making money off of this. They make more money off it not being done than doing it. I mean, would Community Legal Services exist at all if they were doing their job to begin with? And go look at the budget for that. This is an industry. This is the industry. Anyway. So this is basically the form letter again. In addition to its adjudicative role, the LTB provides information to landlords and tenants about their rights and responsibilities under the RTA. To learn more about how to apply to the LTB or learn more about the RTA, you can contact the LTB by phone at 1-888-332-3234 or visit the LTB's website at https://tribunalsontario.ca LTB. Your correspondence suggests that you are aware that most municipalities, including the City of Waterloo, have a bylaw for property standards which sets out maintenance standards for all buildings. Under the RTA, landlords are responsible for keeping the rental property in a good state of repair and for obeying health, safety, and maintenance standards. Municipalities are responsible for enforcing maintenance standards of rental properties. Well, I'm glad he told me that. Again, we've already been there. Tenants can contact the municipality if they believe a building is not being maintained adequately and may request that a municipal property inspector be sent to examine the premises. The property inspector can issue an order requiring the landlord to make necessary repairs to bring the unit or the building into compliance with the bylaw for property standards within a specified time frame. I see from your correspondence that there has been an inspection and an order made at 100A Marshall Street. I encourage you to continue working with the City of Waterloo through the bylaw inspection and compliance process, as they are the appropriate authority for enforcement of the City of Waterloo Property Standards bylaw. The Bylaw Enforcement Department may be contacted at 519-747-8785 during business hours. Should you require it, further information about registering a complaint with the City of Waterloo is available on their website at https://www.waterloo.ca/bylaws-and-enforcement.aspx. Ultimately, tenants who believe their landlord is not maintaining the building properly can file an application about maintenance, Form T6, with the LTB. There are several remedies that the LTB may order if it finds that rental property is not maintained adequately, including requiring the landlord to make necessary repairs and provide compensation to the tenant. You may also wish to seek legal advice about your particular situation. You can reach out to a community legal aid clinic in your area by contacting Legal Aid Ontario's Client Service Center by phone at 1-800-668-8258 or by searching online at http://www.legalaid.on.ca/legal-clinics. Community legal clinics are non-profit legal centers employing lawyers, legal workers, paralegals, and administrative staff to provide free or low-cost information, legal advice, and representation. Once again, thank you for bringing your concerns to the ministry's attention. I hope this information is helpful to you. Please accept my best wishes. Sincerely, Ian Kerr, Regional Director, Municipal Services Office, Western Ontario. So here we have it, the human rights and legal system in Ontario. So as you see, again, you return to the standard form. This is all you get. But the most appalling and damning statement is the one I see from your correspondence. There has been an inspection and an order made at 100A Marshall Street. All these things, yes, this is how it's supposed to run. We know that. But your people, again, the question was to this manager about the conduct of their enforcement officers and the system. And the only thing that we are worthy of, and when I say we, I mean the taxpayers, is to be sent back through the grind. Because as with We Charity and everything else, what we don't know about what they're doing behind closed doors won't hurt them. This has been proven. They don't need to answer. There is no requirement to answer as far as they're concerned. They are fully within their right, and, oh, it's the system's fault. Is that what you're saying, Ian? Well, you know, it's understood. This is the guy who's responsible for the conduct. This is the guy, when it's all said and done, is going to be losing his job and being blamed for it. This is the guy who's trying to avoid being caught. So, actually he sits there and he says, the bylaw enforcement department may be contacted at 519-747-8785. The director's name is Shane Turner. And I think if you believe that this should be done, you need to start calling Shane Turner and Mayor Jaworski and Regional Chair Redmond and demand that they do these inspections on behalf of the taxpayer. Because it's asked and answered. We have a property management company, Atlas Property Management, which is responsible for multiple properties in this region and province probably, but certainly in Waterloo, and they have been very instrumental. So again, this is only one property of theirs where they knowingly or should have known that this is not the code. And by the way, how do you find out it's not the code if you're a responsible landlord? Go ask Dubrick. Go ask any of the top managing legally operating, lawfully operating property management companies and landlords, which 98% of these people are. But they have this hidden industry that's self-propelled through, well, what do you call it? I'm not going to put the words in your mouth, but it's obvious what's going on here. So this is, again, his understanding of hardship is, let's just put him through the whole process again, which he already described as being damaging, harmful, against human rights, against civil rights, showed impropriety by the participants, especially Ministry of Municipal Affairs and Housing, of which this regional manager is directly responsible for. So the question was, how often is this happening? The Municipal Affairs and Housing is responsible for the Land Registry Office. There is nobody else who is responsible for that. They control this whole thing from inspections to enforcement. And when they are and it appears they are interfering with proper filing of these liens against the property, which would affect evaluations under mortgages. Because again, a bank under proper rules cannot mortgage it for more than its actual value. Matter of fact, I think it's what? No more than 2/3 of the actual value or something like that. And it has to be a secure. Anyway, yeah, let's go. Yeah, I need to go and go to human rights, and I need to put in a process. So in order to get these these inspections, they're saying it's less hard and less cost-wise for us to have to go through this whole process again. And more importantly, because of what's going on, well, there's a process where you can complain to the city hall. Why? We just did. So we complain about the complaint not being handled. Again, misuse of taxpayers' funds, because had they done their job in the first place, we need to find out how much it would cost for a straight inspection if they came here, and we need to demand through. They cut us off from access to the records without having to pay a lot of money for it. So why doesn't somebody go out there and say, how many of these work orders have been written, and how many have been registered for enforcement, and how many are not completed or followed up on? Because that's taxpayers' dollars. I mean, how many times they come here? They should have came here once, handed him a piece of paper, said, hey, that license isn't hanging up. You were licensed, so hey, where's the license, buddy? Because that's number one requirement of the license in order to make people aware of the situation. We're not seeking legal advice. We are asking them what, again, the law is clear. There's clarity. They should have, because again, it changes the whole dynamic of the case. We were not in arrears at that time, and if it's unlawful rent, there are no arrears. Matter of fact, all that money that was paid beforehand has to be paid back. Now imagine that if they had to do that at a lot of the properties for Waterloo, or for Atlas Property Management, because Atlas Property Management, for every property that is in Waterloo that is not official student housing on a campus or a new building, this is by design, people, and it's about writing the paper, the contracts of how much money they got coming into the area. I'm sending a warning. It's just a warning bill. Anyway, if you believe that it's cheaper again, hardship. Thank you, Ian. You just proved our case. You just proved our case beyond a shadow of a doubt as far as human rights. So that means the taxpayers now are going to be on the hook for damages to Austin, to Kerry, to me, to Denise, and I'm making the human rights complaint on behalf of every disabled person in Ontario, every underrepresented person in Ontario, every legally operating landlord in Ontario and property management in Ontario. Because with human rights, you can make it on behalf of anybody. So I'm doing the whole gamut. And I invite anybody else, if you have been misused by this landlord-tenant board, because the evidence is there, just go look at their decisions. Repeat offenders, the same landlords, same properties, same issues. Same landlords, different properties, same issues in the province of Ontario. Again, hey minister, if I got 1 car or 10 cars, does the law only apply to one, or does it apply equally to all? Where's the rationale? There is none. The only rationale is they are open for business, and this is what they mean. Willing partners, and the more that they're allowed to do this adds to manipulation. Again, they manipulated the tax roll so much with this stuff. If this is what's going on, and it looks like it is, and we need a full answer and a full criminal investigation into this, because this is criminal conspiracy. I hope you agree with me with that. At the very least, there's definitely red flags here. The outcome for us has already been decided. Like I said, here we go, right? The only thing left is human rights, and to try and carry on as best we can given the circumstances and the direct message from this regime. We scandal, same thing. We don't need to know what's going on there. They don't have to tell us, right? What happened in the nursing homes? It's really funny. Again, you're talking a generation where those are the last pensions that were covered up until death. They already undermined the ones that were in employment, using the tribunal system to do it. Tribunal system with Workplace Safety and Insurance Board has also been instrumental in setting up the scenario for the right to refuse treatment if cost outweighs benefit. So if they're doing it from cost outweighs benefit, yeah, the cost of being caught and having to undo all this damage outweighs the benefit to the people. What? Anyway, we're going to get to it. If you have been, if you feel that you have been arbitrarily, and especially procedurally, just bowled over and pushed out of the way because of tenant rights in dealing with either legal aid, community legal services, or the landlord-tenant board, the address is Notwithstanding, 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 at Execulink, EXECULINK.ca. Notwithstanding at Execulink .com. Contact with basic information, and the best way to deal with this, we are doing a federal human rights case as well, including the legal system, the disability system, and Arch Disability Management. You will be named in all suits because your management of the disability system is criminal, or should be. Anyway, we a referendum should be coming. Is there a reason for municipal government to exist? Because the amalgamation is here. They're just playing with everybody. Mayor Jaworski is a regional councillor and mayor of Waterloo. That is two branches of government. In order to keep any issue going, they just need three branches of government to agree on it. So the minute one other branch of government gets in the room with Mayor Jaworski or anybody else with this distinction, because Mayor Jaworski is not the only one and not the only council where they have these people with dual conflict of interest. Just for the mere fact of the preponderance that the reason why there's supposed to be three individuals is because that's three layers of checks and balances. Again, checks and balances are just the checks going into government. The balance is that they keep the power with the people providing the checks. As always, it's their privilege. Something for us to answer. But anyway, thank you, Ian, for giving us the expected response, because again, you're the one with the most to lose. You are the ringleader of this tax raping and pillaging unlawfulness. So anyway, human rights in Canada, security of person in Canada, equality under the law. My dollar is as valuable as his. Anyway, it's time for me to go. That's enough for one day. Please stay well. I hope everything's good with you and yours. Be well. Practice safe practices. We're in this together. Well, at least that's the general consensus. Everybody at this home right now, yeah, we're in this together, but against the world, I guess. It's just a matter of perspective, and everything in life is just a matter of perspective. And the time for non-participation is over. So the last step is to go and make it official, go to the MPs, go to the representatives and ask for assistance officially, and get a written response, because that's going to be necessary for the human rights complaints. But again, if you feel that you have been treated notwithstanding under the law in Canada, please email us. If we put our cases together, that makes it stronger. I invite you to join us. We are standing right here. and maybe we should start a movement. We are standing right here is the tagline. And my hope federally is to have the notwithstanding clause removed from the Constitution, or the Constitution torn up, and let's have a brand new one based on real freedom, not in indentured servitude. The charter of the banks needs to be changed, because again, you have to question yourself. You've been doing real good and all that. You go into your bank and they're saying, oh my God, yeah, investment portfolio, do the Pacific Rim, Pacific Rim, Pacific Rim, that's where the money is. Yeah, invest there, invest there, invest there. Well, guess what? That's what moved all the jobs from North America over to Asia and Pan-Asia. That bankrolled the undermining of every mortgage in Canada, but North America. This is an agenda done by the banks. And like I said, serious questions need to be asked, especially now that they're doing all these backroom deals. Because everything they do gets put onto your mortgage. Or I should say your contract of indentured servitude, where they have convinced you that your greatest debt is your greatest asset. And that the more you get into, the more assets you acquire through debt. Oh, well, you know, so what business are they in? You know, you're not stupid. You're just plain dumb. Hopefully you get smart. Please, you know, you need to, don't do it for us. Do it for you. Do it for the not wasting taxpayers' money. Pick whatever reason you want. But you know what? Keep working hard, because thanks to all this and the way they do things, there's going to be a payout again. And bought silence, because that's the system in Canada. That's how it's managed. You know, it's funny, the Queen has a saying, everybody must pay except for her. She must be nobody then, because if you're not everybody, you're nobody, right? And nobody's above the law. Just remember that. The message is clear. Okay, anyway, we're going to persevere. There is a God.